Chairman Goof, we are live.
Thank you, Ryan. I'd like to welcome everybody to the April 21st Pitt County Planning Board meeting. We'll bring the meeting to order with Ms. Otten. If you will call the roll for us, please.
Fred Austin.
Here.
Faye Barefoot.
Here.
Don Brown.
Here.
Naomi Buck.
Here.
David Davenport. Brad Guth.
Here.
RJ Hemby.
Here.
John Landron.
Here.
Steve Little.
Here.
Tucker Moore.
Present.
And Maria Rogerson.
Thank you, Ms. Otten. Now, if we could have a moment of silence, please. Thank you. Now, if you'll all join me in the Pledge of Allegiance. I pledge allegiance to the flag
of the
United States of America
and
to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Now, hopefully everybody has received your minutes from the March 17th meeting. Appreciate Ms. Otten putting those together. I think they were only 10 pages this time, but hope everybody had an opportunity to review those. And are there any corrections or additions to the minutes? All right, hearing none, if I could have a motion for approval.
So moved.
Mr. Little made the motion. Do I hear second?
Second.
Ms. Barefoot second. And Ms. Otten, if we can do a roll call for approval.
Yes, Mr. Chairman. Fred Austin.
Approved.
Faye Barefoot.
Approved.
Don Brown.
Approved.
Naomi Buck.
Approved.
Brad Guth.
Approve.
RJ Hemby.
Approved.
John Landron.
Approved.
Steve Little.
Approved.
And Tucker Moore.
Approved.
All right, so the minutes have been approved. And again, Ms. Otten, thank you very much for preparing those. And our next item on the agenda is public addresses to the board. Is there anybody here in the meeting tonight that needs to speak or would like to speak to the planning board? I don't think we had anybody sign up to do that. So we'll move into our public hearing. With our first public hearing is the Pitt County Zoning Ordinance Amendment. And I believe Eric is going to take care of that for us.
Thank you, Mr. Chair. The way we're going to do these amendments tonight, we're going to present the three ordinances that are up for public hearing. And then following the presentation, we'll have a public hearing for all three of those at once. Go ahead and start sharing my screen here so everybody can see. So Jason and I will be presenting these. I'm going to present first the zoning ordinance amendments, and then Jason will move into the subdivision and manufactured home park ordinance amendments. So again, these amendments are specifically for the purposes of ensuring compliance with Chapter 160D of the North Carolina General Statutes. We also have several additional amendments that are not related to 160D, and these are proposed mainly for those items that need some additional clarification or need to provide some more consistency with other parts of the ordinance or to address particular items of concern. And just to kind of reiterate the background of this, Chapter 160D of the General Statutes, it's a complete reorganization and modernization of the planning statutes in the state. And this is the first time since 1905 that they've been updated and reorganized in this manner. What it does is it repeals the previous enabling statutes for counties, which was 153A, and also the enabling statutes for cities, which was 160A. And it takes them and it consolidates them into a single chapter that's renumbered as 160D. So now counties and cities both fall under the same regulations, whereas once you had one set for counties, one set for cities, and they were similar, but there were still differences between them. So this takes them, consolidates them into one, so we're all sort of operating under the same rules. Also takes it in where previous statutes were kind of spread out throughout the regulations. It takes them all and puts them in one more logical, cohesive order. So the law allows local governments until July 1st of this year to amend our ordinances to make sure that we're complying with that law. And just for anybody that might be viewing at home or that's interested in this, copies of the draft ordinances that we're reviewing tonight are available on our website. We've set up a special website for the 160D changes. It's www.pittcountync.gov/160D, and they can find the draft ordinances there with all the marked up changes, as well as the summaries of everything that's being proposed for amendment. So with that, we'll get into the zoning ordinance amendments. And as you remember, last month we went a lot more in depth in terms of provide a lot more detail in terms of what is being proposed to be changed. I'm not going to go into that as in depth tonight. Kind of try to keep it a little bit shorter so we can get through all the amendments. But in terms of the 160D changes specific to the 160D, we're looking at removing the conditional use permit language. Again, we have to make sure our terminology is consistent with the statute. The statute has removed all references to conditional uses, and now everything is considered a special use. So I'll kind of expand on that here in a minute. We're also going to be broadening the conflict of interest standards. The statutes have increased those or have spelled out more clearly what is considered a conflict of interest. Also, clarifying the quasi-judicial procedures and evidentiary hearing requirements, as well as the Board of Adjustment requirements. So not a whole lot of changes there, but there are some tweaks to it that we're incorporating into the ordinance. Also revising our vested rights and permit choice language. The statutes did change a lot in terms of vested rights, in terms of the periods of vesting or what can be vested and how. And then also permit choice is also where if you have submitted an application for an approval and your regulations have changed after that approval, but before it was finally approved, or I should say after the submittal and before it was approved, you then have the choice to decide which regulation would apply to that application. So a few tweaks to zoning amendments, both in the requirements and the consistency statements. Y'all are familiar with the consistency statements. There's a little more language in the statutes now as to how those have to be formed, or what kind of process or what shape those statements have to be in. And then also, again, just making sure our terminology and our definitions are consistent with the state rules. We're adding a new use that's now allowed by 160D, which is temporary healthcare structures, and also going to be adding some development standards for that. And then also throughout the entire ordinance, making sure all of our statutory references are consistent in reference 160D rather than the old 153A language. Now, in terms of the other amendments, as I mentioned, conditional use permits are no longer, that terminology is no longer allowed under the statutes. And as we've discussed with the board before, the county commissioners who hear conditional use permits, they've stated that they want to retain some authority to review and approve some of those uses. So we are proposing to take the conditional uses and the special uses that we have that are heard by the Board of Adjustment and reclassify those to Class 1 and Class 2 special use permits. So Class 1 is what the old conditional uses were. Those will continue to be heard by the Board of County Commissioners. They'll be designated as S1 in the use table. And then likewise, the special use permits that we have now will be classified as Class 2 special use permits. And those will be shown as S2 in the use table.
Hey,
yes, sir.
do me a favor. Would you,
Yes, sir.
I'm sorry, can you back up? I think it's two screens now. I thought I saw something. I'm just curious that I just wanted some clarity. One more, back up one more.
Okay.
Yeah, temporary healthcare structures.
Yes, sir.
What falls under that?
That is when, if you are a caretaker, if you have somebody that is in need of care, and you need to basically provide a place for them to live on your property, it's almost like a mother-in-law suite, but it's a temporary for somebody who is handicapped or is in need of some kind of special care. There are standards. The state provides certain standards in terms of how long those structures can be, or not necessarily how long they can be on the property, but in terms of how many you can have on the property, what the setbacks are. And then once that structure or that care is no longer being provided, they have to be removed within a certain period of time.
So it wouldn't control anything that was added on to a home then, right?
No, sir. If it's an addition, it'd be an addition. This is mainly for detached accessory structures that are used for that purpose.
Super good. Thank you, sir.
Yes, sir. So to get back with the class 2 special use permits, the one change we are looking at adding to this is the daycare centers for adult and child and daycare, residential daycare facilities and wedding event facilities. Those are currently conditional uses. We're proposing to move those to the class 2 special uses so that they'll be heard by the Board of Adjustment. The ordinance basically defines, it says that conditional uses should be uses that involve some expenditure of public monies, or it's listed as controversial, and we're looking to change that as ones that have sort of could have an impact on surrounding properties. Daycares and wedding event facilities are fairly innocuous type uses, and this will kind of get those off the commissioner's plate so they can proceed with the county's business. And we'll also give an opportunity for the Board of Adjustment to convene and hear some cases. But again, ones that we feel like would be just more appropriate to go to the Board of Adjustment rather than sticking with the Board of County Commissioners. But the commissioners would still retain authority over things like mining operations, solar farms, salvage operations, landfills, and that sort of thing. Some changes to Table 5-1, the table of permitted uses. I'm looking at adding a column that would cross-reference the Section 8 of the ordinance, which provides the development standards for individual uses. Also adding some uses that are in the ordinance that maybe have definitions or have development standards, but for some reason aren't shown in the table. And those are manufactured homes in the R40, as well as the new temporary healthcare structure, adding that as a use. And then sanitary and solid waste landfill. There was a definition for that in the ordinance, but it wasn't listed in the table. And also we're adding that to the development standards. And then also some uses that we're looking, just making sure they're consistent with those development standards. Golf driving range, fire station, emergency medical service, outdoor theaters, solid waste disposal, and radio, television, or communication towers over 60 feet in height. Essentially cell towers is what that covers. And with that one, we're proposing to allow those in all districts, because as cellular technology has become much more of a public necessity and it's more of a utility, it doesn't make sense to restrict them to just certain districts. They need to be allowed in all of our districts so that they can maintain the coverage areas that they need to. But again, the other ones are just making sure that those districts that are shown in the table also correspond with the districts that are shown in that Section 8 under development standards. So then conversely, going back to Section 8 development standards, also making sure that that meets up with what's in the table. So trying to go through and just make sure everything is consistent. Adding contractors, heavy construction to the contractor uses. Again, it's in the table. It was shown as having development standards, but it wasn't listed under that section. Daycare uses, making sure that the zoning districts match up with the table. Clarifying farm supplies and equipment and farm supplies other. They have the same standards, but one is a retail trade and one is a wholesale trade. So it's just trying to make that distinction between the two so that if you're going back and forth between the table, you know which section to look into and where to find it. Golf driving range, again, making sure that's consistent with the permitted use table. As I mentioned, the sanitary solid waste landfill, adding that to make to those other landfill uses to reflect it in the ordinance. Private campgrounds and RV parks, making sure that it's shown that it's allowed in the RC district to be consistent with the table, but also amending the interior road access width so that it can accommodate emergency vehicle access. The ordinance currently says it has to be at least 10 feet wide, but the fire code in some instances requires a wider width. And so we want to make sure that when it's reviewed, that the fire marshal, when he reviews the plans, that he can dictate essentially what that width will be based off the fire code. Then again, amending the cell towers, those communication towers over 60 feet in height, to allow those in all of our districts. And then retreat and conference center, again, adding a district to make sure it's consistent with the permitted use table. Solar energy facility, what we're proposing for this is to amend the use separation to measure it from the boundary of the facility rather than the property line. This is similar to mining operations. And what we've seen with the last couple of solar farms that have come in, they're large. And so they include several property owners. And a lot of times these developers will have lease agreements with 4 or 5 different property owners, and the facility itself covers all these properties. And so if we have a setback, you'll have interior property lines that are then subject to these setbacks rather than just allowing the facility to encompass the whole property. So similar to mining operations, we want to just make sure that the boundary of the facility that's shown is where the setbacks we measured from, because it's all going to be under one control of the operator or the utility company or whoever is operating or owning the facility. So there won't be any necessarily need for additional setbacks interior to the facility. Then solid waste disposal, again, adding that to the GI district, and then outdoor theaters, also adding those to the HC district, or the heavy commercial district. Section 10 of the ordinance is currently off-street parking, stacking, and loading areas. We're proposing to amend that title to off-street parking and landscaping requirements. And the reason for that is because we want to amend our general landscaping requirements. Currently, they only apply to those non-residential uses that have 10 or more parking spaces. If that use has development standards that require screening, then that'll be required. But just general permitted by right uses, until they hit that 10th parking spot, they don't have a landscaping requirement. So we have instances where we've had non-residential uses that abut to a residential property, and there's no screening between them. So it's just visually open to that residence. So we would like to amend this ordinance, or this section, to require those landscaping buffers along the public rights of way, as well as also to the adjoining property lines for any non-residential land use, not just those ones that have 10 or more spaces. And this would also exclude bona fide farming activities, because while they're non-residential, they're exempt from our zoning requirements. So they don't have to provide that screening around their activities. Then under that same section, in terms of the alternative screening methods, typically with just as I can back up, the vegetative screening requirement is typically a 10-foot buffer yard with trees spaced 1 tree every 40 feet and shrubs one shrub every 4 feet on center. So it's not a thick, dense vegetative screen, but it's just something to provide some sort of break between the two uses. But the ordinance does allow for some alternative methods, and one is that they can have a wall or an opaque fence, and that would, the ordinance currently says they can reduce the buffer width based off that, but it doesn't specify how much that can be reduced. And so, being sort of subjective language, we need to make that more objective and change that from, or specify an exact amount of reduction. And so what we're proposing, essentially, if there's a wall or opaque fence, it would reduce that buffer yard in half to 5 feet. And then also amending the minimum height of screening berms. Currently, the ordinance says that they have to be a minimum of 3 feet. And we're proposing to amend those to 5 feet. That would correspond with the wall requirement in the previous section, where it's a 5-foot fence minimum. And then also require the berms to be planted with some type of permanent ground cover of natural vegetation. That way it would stabilize those berms against any kind of erosion so that the soil isn't washing onto adjacent properties or causing any other problems. Then in terms of other sort of general amendments that we're doing or minor amendments, we're looking to reduce the time limit to establish a conditional zoning district from 2 years to 6 months. We've had some discussions with the board, I think last month, about we have one use in particular, one district in particular. The 2-year period is just too long to establish or for us to effectively enforce them to establish that district. So over the last few years, as we've gotten more and more conditional zoning districts, we've realized that we just need to be able to begin those enforcement proceedings sooner so that it doesn't drag out over that full 2-year period. So that's what we're proposing with that section. Also, to remove the certificate of zoning compliance. That section essentially treats that as almost like a certificate of occupancy with inspections. We've never done that. It's in the ordinance, but it's not been part of our process. We issue a permit beforehand and we do some inspections, but we don't issue an actual certificate of compliance. A lot of uses we continue to monitor, particularly conditional use permits, special use permits. We go out on a biannual basis for some of those and do continual inspections to make sure that they're still meeting their requirements. Also updating and amending the executive summary and commentary, updating our appendices, including sketch plan in our application charts that wasn't included in there before. Also making the language more gender neutral. So in areas of or sections of the ordinance where it referred to chairman or vice chairman, we're just changing that to chair and vice chair. And then also just correcting any sort of formatting errors, any kind of typos and numbering errors. And so with that, I'd like to turn it over now to Jason. He can go through the subdivision and manufactured home park ordinances. Does anybody have any questions before we proceed on with that?
Thank you, Mr. Gooby. Yeah, I was just going to ask if we could have a minute to see if anybody had any questions. I do not hear any, so we'll move on with Jason.
Thank you, Mr. Chairman. Subdivision ordinance amendments. What's covered in this is we'll update the North Carolina general statutes, references and definitions. We'll update the hearing types. We'll broaden conflict of interest. We'll clarify approvals, clarify that North Carolina Department of Transportation is who is controlling access. We've defined vested rights and permanent choice, and further clarified open space and corrected some numbering errors. Specifically, what we are changing and revising is the state statute references. This affects section 1, 100, 101, 104, and 121. Those will be showing 160D instead. We'll amend section 9. This will replace the hearing type to legislative. We'll amend section 123. This will clarify development approvals that they attach to and run with the land. And we'll define vested rights as well as reference the state statute. We'll amend sections 124 and 125. This will clarify how approvals and electronic copies should be handled and that they are protected in PDF format. We'll amend section 142. This will clarify how driveway permits are handled and that access is granted by the North Carolina Department of Transportation. We'll amend section 156. We'll restrict the use of open space specifically to prevent septic areas from counting towards the amount set aside. We'll add the definition of vested rights as well as the state statute. We'll amend section 160. This will replace the hearing type with legislative. At this time, it states public. We'll amend section 166, and this will add language to broaden the conflict of interest. This will be a new section that will cover everything as far as conflict of interest is. We'll amend section 170. We'll add terms that are defined by 160, and this will include decisions and hearings. One clerical note that we'll make, we'll add to title Part 3 appendices, so it's consistent with the table of contents. And with that, does anybody have any questions as far as the subdivision ordinance goes?
Don't hear anybody speaking up, Mr. Bryant, so do we need to move to the public hearings now?
Mr. Chairman, we'll have the manufactured home park ordinance. We'll have similar amendments, but it is just slightly different to conform with 160D.
Okay,
So moving to the manufactured home park ordinance amendments. These will update the general statute references and definitions, hearing type, broaden conflict of interest standards, clarify approvals, define vested rights and permit choice. The statute reference was changed in sections 1 and 101. We'll amend section 23. This will clarify development approvals attached to and run with the land. We'll define vested rights. We'll amend section 24 and 25 to clarify how approvals and electronic copies should be handled and protected in PDF format. Section 101 will replace the hearing type with legislative. Section 110 will add the conflict of interest. Section 121 will define vested rights and reference the state statute. Section 131 will add terms that are defined by 160B, including decisions and hearings. And the proposed amendments will ensure compliance with Chapter 160B of the North Carolina General Statutes and are consistent with the goals of the Pitt County Comprehensive Land Use Plan to maintain an effective jurisdiction-wide land use regulatory program. Staff recommends approval of the proposed amendments with a proposed effective date of July 1st, 2020.
all right. Are there any questions now for Mr. Bryant? I'd gotten ahead of myself a minute ago, so if you have any questions for him, please speak up. And if not, we will open the public hearing to hear any public comment on any of these three ordinance amendments.
And Mr. Chair, if I may, this is Eric again.
Sure.
Just want to reiterate too that as you see on the screen with the hearing, we'd like to entertain public comments, and after the comments, we'll be asking the board to make a recommendation to the commissioners, and the commissioners are scheduled to hold their own public hearing on May 17th regarding these.
Okay. Is there anyone here at the meeting that wants to speak on any of these items? All right. Hearing none, I will ask for a recommendation from the planning board members to make the recommendation to the Board of County Commissioners for these ordinance amendments.
I move we recommend adoption of these approval of these ordinance. I'm sorry.
Second, Don Brown.
Thank you, Mr. Little, and thank you, Mr. Brown. Ms. Otten, if we could have a roll call vote.
Brett Austin,
Approved.
Faye Barefoot,
Approved.
Don Brown,
Approved.
Naomi Buck,
Approved.
Brad Guth,
Approved.
RJ Hemby,
Approved.
John Landron,
Approved.
Steve Little,
Approved.
and Tucker Moore.
Approved.
Okay.
All right, well, we'll make this recommendation to the Board of County Commissioners and move on to our next item, which is Mr. Jordan Smith, our Assistant County Attorney, is going to share with us some subdivision training. And I appreciate Mr. Smith being here with us this evening. And I appreciate, Jordan, your kind email after our last board meeting. And I think this training will help everybody. So I hope folks will have questions. And with that, I'll turn it over to Mr. Smith.
Thank you, Mr. Chair, members of the planning board. Let me share my screen here. Okay. All right. So I try to do something like this periodically, and quite frankly, it's been some time since I last did any training like this. So here I am tonight before you, and I'm happy to share a copy of this presentation to anybody. If you want it sent to you by email, just reach out to me or James or Tab or anybody, and we can get it to you. So to begin with, I want to talk about two primary functions that you as planning board members carry out. You do some other things, but the vast majority of what you do can fall into one of two buckets. First, you make recommendations to the Board of County Commissioners on zoning matters, text amendments like you just heard from Eric, and also map amendments, rezoning. You also, secondly, you approve, conditionally approve, or deny subdivision plats. It's important to distinguish these two things. They're very different in several ways. One thing that I want to talk about tonight is in the first instance on zoning matters, you're making a recommendation to the Board of County Commissioners. They can follow your recommendation or not. The Board of County Commissioners is the decision maker with zoning matters. With subdivision review, you are the decision maker. You're not making a recommendation. You are the decision maker. I've created this chart to try to condense the overall subdivision review process into one chart. And so it's limited in some ways, but I really just kind of want to orient y'all to where we're at in the process when you hear subdivisions. It's on the chart as step 2. It's a little bit misleading. Step 1 is a purely optional step. And quite frankly, I don't know if many developers, subdividers avail themselves to that. Step 2 is the first required step. That's the step you hear. I just want to offer that to put it in context that this is early on in the process. You look at preliminary plats, and those plats simply have to show lot layouts, where roads are going to go, and some other features. And if y'all approve it, that means the construction plan can be submitted. And the construction plan, that goes to staff, the technical review committee, and they review detailed technical drawings that deal with many things that you don't see on the preliminary plat, things that have to do with drainage and erosion and specifications of streets and some other detailed engineer drawings. So I just offer that a lot happens with subdivisions after y'all review them.
So Jordan,
Yes, Mr. Little?
may I ask then as we talk about that, because I think most of us, if not all of us, had a call from, oh Lord, folks help me, Ms. Candace, after our meeting last time, because she was expressing to us, I believe she may be part of the technical review committee and was just asking if we're listening enough to that piece. But in this, are you saying that they're reviewing and sharing with us that yes, it's okay to move forward? And I guess where this comes back to in a lot of these cases we're hearing now and plans, it's talking about if this is too many septic tanks, if there's enough runoff, if we're getting trouble with drainage and this kind of stuff. And so are we asking enough questions about certain plots as they come to us? Just the question.
So, y- so, I mean, are you asking me, can you rephrase your question? I'm not sure I exactly followed.
Are we asking enough questions when we see that, okay, technical review committee has said, move on? There again, who is the technical review committee?
Well, so Mr. Little, I think that's a good question. What I would say to you is at the preliminary plat stage, all the subdivider has to offer on the preliminary plat is proposed lot layout and roads. So a lot of things about drainage, they may not know yet because they can hire experts or whatnot, and they may have the construction plan ready to go. The construction plan is not submitted until a preliminary plat is reviewed. There are some other things that I'm going to address at the end of my presentation about whether or not our ordinance speaks to these concerns in any way and what that means for your consideration. So I hope I can answer that question you asked through the series of this presentation, if that's all right. And if I don't, feel free to, at the end, we'll talk about it in more detail.
Hey, Jordan, I'll step in. This is James, just to answer one of Mr. Little's questions about who serves on the technical review committee. And we've had this technical review committee set up since our revamped subdivision ordinance came into play back in 1991. And there are 6 agencies that serve on that. So depending on availability, it may be different staff members involved, but the same agencies. That includes the planning department, the engineering department, the environmental health department, of course, for the septic systems. Emergency services plays in a lot with certainly emergency response and fire flow or fire protection. The Soil and Water Office, as well as the Department of Transportation. So those are 6 agencies that review your preliminary plats and provide a recommendation before your planning board meeting. So just know that's a technical, those different staff members give you their best recommendation based off standards that are in our subdivision ordinance. And we've been doing that, like I've mentioned, for about 30 years now.
Mr. Little, you're muted.
There you go. I'm sorry. And listen, I appreciate what you just shared, James, and just again reminding me who's on that committee. But at the same time, as you know, it seems like recently we are being questioned right much from those folks that have adjoining properties or those that have others that have interest in some of these plans when they come up and just tell us, or at least express their feelings and wanting to know if we've really looked at it close enough. So again, you're right. There's the experts. That's who I got to go on. But at least I hope they don't mind being challenged from time to time.
And Jordan's presentation is really going to speak to that, Mr. Little, as far as the public or adjacent property owners, how they weigh in and what the responsibility of the planning board is in taking future action on the preliminary plat. So I'm going to turn it back over to Jordan.
Yeah.
And I'll be happy to be quiet. Okay.
No, Mr. Little, I really, I hope I'll answer those questions through the course of this presentation. While we're here on this chart, I just want to point out the preliminary plat, the developers only required under the ordinance to supply some basic information, and that's this information right here. So to these points that a lot of adjacent and neighboring property owners talk about, first, one, our ordinance may not speak about those concerns, period. 2, if our ordinance does speak about it, it more than likely is going to be at the construction plan review, which is after you approve a preliminary plat. So that's one component, but I really hope I'll answer the rest of your questions. And if not, we can come back and have further discussion.
Got it. Thank you, sir.
So also, it's important to talk about different decision types. It's important to know in local government, not all types of decisions are the same. And what I mean by that is depending on what type of decision you're making, it drives what type of hearing is required, if any at all is required. It drives what type of authority or latitude or discretion a decision maker may have or not have when making that decision. It also drives what type of appeal or legal challenge may follow. And so these are the three decisions that really may be relevant in a land use context. And I'll talk about them all three in more detail here. So a legislative decision is when the governing board enacts a local law, an ordinance that's going to apply countywide, jurisdiction-wide, it's broad applicable policy. That's like the zoning ordinance, the subdivision ordinance, when they adopt, amend, or repeal that. Any hearings on these types of decisions are legislative, or we used to call them just public hearings, but now under 160D, we're calling them legislative hearings. And they're intended to solicit public opinion about the desirability of the proposed policy. And what I really want to drive home with this legislative decisions is that the decision maker has wide discretion and latitude when making the decision. They can consider almost anything. There are a few exceptions to that, but generally almost anything is fair game. They can public opinion, their own political views, their philosophical views, how they think government should or should not function. Simply put, in a legislative decision, the decision maker gets to decide if he or she thinks this is a good idea or not. The remedy for this, someone dissatisfied with this type of decision, generally is at the ballot box, or to let their elected folks know they're unhappy with that decision. Generally, there's not a remedy at the courthouse. There's exceptions to that, but it's really not worth getting into for the purposes of this presentation. So almost any ordinance, adoption, amendment, or repeal is going to be a legislative decision. When the Board of County Commissioners considers all those ordinances that Eric and Jason just presented to y'all, they'll be making a legislative decision. So it applies in the land use context, but it also applies to things like animal control. We have we have one consolidated animal control ordinance with different offenses. When the Board of County Commissioners adopted that and amends that, that's a legislative decision. It also applies to things like when the commissioners adopt their annual operating budget. That's a legislative decision. Next is a quasi-judicial decision. And these decisions involve the application of existing ordinance standards to individual situations, to individual permit requests and applications. And it's going to be a quasi-judicial decision if those standards that apply require judgment and discretion, meaning those standards are somewhat subjective, meaning the standards to be applied are what I would call gray. They're not black and white. People may have different interpretations about those standards. Here, the decision maker is not asking, is this a good idea? Instead, they're simply asking, does this applicant meet all those requirements adopted or contained in the ordinance? For a quasi-judicial decision, there's a required evidentiary hearing, and where the goal of that is not to solicit public opinion about whether it's a good idea. You're trying to determine facts to apply to the decision. And as the name implies, it's almost like a court proceeding. It's not quite as prescribed and formal as a court proceeding, but there's many similarities. testimony is given under oath. Parties can cross-examine witnesses. There can be objections made to someone's testimony that the chair or the body has to rule on. And expert testimony is needed for many things. For example, real estate. There's a question about real estate value. You just can't take a layperson's testimony about value. It has to be somebody who has some credential, a certified real estate appraisal. A lot of engineers are involved in this to prove certain things depending on what the ordinance may say. There's also a bunch of rules that govern quasi-judicial decisions. And the decision maker cannot have a fixed opinion about the matter. They have to be open-minded. Parties cannot communicate with the decision makers outside of the hearing. That's called ex parte communication, and it's not allowed. Decisions must be reduced to writing and contain findings of facts and conclusions of law, and the parties are allowed to challenge that decision in Superior Court. And oftentimes these type of decisions are challenged in Superior Court because, as I said earlier, the standards are somewhat subjective, and it's possible for people to have different interpretations of the same thing. So oftentimes these do end up in court. Examples of these are some of the things that Eric talked about. Special use permits. The Board of Adjustment hears exclusively quasi-judicial issues. Special use permits, variances, appeals of interpretations made by those who administer our land use ordinances. And the Board of County Commissioners also hears some quasi-judicial things as in the class 1 special use permits. I know that some of y'all are maybe current members of the Board of Adjustment or previously served on the Board of Adjustment. So maybe this is familiar to y'all. Quasi-judicial decisions are not something historically that the Pitt County Planning Board hears. Finally, there's administrative decision. And so administrative decisions involve some fact finding, but here we're talking about objective, non-discretionary standards. If all the technical standards of the ordinance are met, approval must be issued. There's no hearing actually required under state law for administrative hearings. And the decision maker has no authority to impose conditions or consider factors beyond those standards that are outlined in the ordinance. So here, this is like a quasi-judicial decision in that we're asking, does the application meet the standards provided in the ordinance? It's different from a quasi-judicial decision because here we're dealing with standards that are objective. They're black and white, so to speak. They do not require the use of judgment and discretion. Administrative decisions are also different from quasi-judicial decisions in form. No hearings required. Really, the idea with an administrative decision is you ought to be able to look at essentially the paperwork and make a determination about whether or not the standards of the ordinance are met or not. So once again, you're not necessarily asking, is this a good idea? Simply asking, does this meet the standards contained in the ordinance that apply to this type of project? And also with administrative decisions, if an applicant meets the standards of the ordinance, the applicant has a legal right to the permit, and if necessary, may go to court to receive a court order requiring that approval or permit. The example of that is preliminary plat review by the planning board. We'll talk more about this. So let's apply what I just talked about, the 3 different decision types to the real world. The governing body, the Board of County Commissioners in our case, makes a legislative decision when it adopts, amends, or repeals a subdivision ordinance. Depending on how they set that ordinance up, depending on the language and how the standards are defined in that ordinance, individual projects, it's either going to be a quasi-judicial review or administrative review. It can be done either way in North Carolina, but it's determined by the local government when they create the subdivision ordinance. And this is just really a chart, kind of, in my mind, illustrating what I just said. For those who may, some people are visual learners. So the decision of the governing board to adopt the subdivision ordinance is legislative. They can consider a wide host of things when doing that. And depending on what type of language, what type of standards is in the ordinance, drives whether or not they have a quasi-judicial review or administrative review. It's going to be quasi-judicial if the standards are discretionary and subjective, open to interpretation. It's going to be administrative if the standards are objective. And y'all may be asking me to show you the difference in what type of standards may be. You may be asking me to illustrate what might be some different types of standards to compare. So this chart, this is language pulled from other local governments. So a quasi-judicial standard that's open to interpretation might say something like, will not have a significant adverse impact on traffic. That's something that you can't ascertain by just simply looking at a preliminary plat. That's something that you need some type of testimony on. And given the rules of quasi-judicial proceedings, you're probably going to have to hear from a traffic engineer, somebody with a credential to testify on something like this. Some other jurisdictions have this standard: design must be compatible with the surrounding neighborhood. This is what I mean by subjective. Obviously, people could have different points of view on what that means, and you have to have a hearing to ascertain that and apply it to a project. Now, contrast that with the language for administrative. These are some examples of standards that would be administrative. So lot configuration. We require lot configurations to be shown on our preliminary plat. And that's just, for instance, say if the minimum lot size is half acre, you can tell by looking at the plat whether or not all the lots meet that or not. You really don't need a hearing for anybody to come testify about that. It's apparent from the face of the document. Right-of-way widths, whatever those must be, will be shown on the plat. Either they meet them or they don't. So that's the distinction between what I mean by objective and subjective standards. These are what I would call gray standards, and these on the right would what I would call black and white. So I think I already alluded to this, but each local government in North Carolina can create their subdivision process to their liking. So maybe you're familiar with another jurisdiction who does it one way, and that's totally appropriate under North Carolina law. There's wide variation from local government to local government. But most ordinances, and I'm quoting here from David Owens from the UNC School of Government, from his text, he's the leading authority on North Carolina local government land use law. His text, it's a very good book for someone like me and James. Most ordinances, according to him in North Carolina, most subdivision ordinances, a preliminary plat approval is an administrative decision because the standards applied are entirely objective. And that's certainly our view of our subdivision ordinance. And in fact, we've taken efforts to ensure that's the case over the years. Some years ago, we thought that our stub roads provisions was a little bit subjective. We said that stub roads were required to adjacent parcels if some of these factors were met. Those factors weren't black and white, and so we went back and we changed those factors, and now it's really a formula. If adjacent parcels are a certain size and not encumbered from development with a conservation easement, then stub roads are required. And I believe it's 1 or 2 per subdivision. James or Jason could speak to that better than I, but we've taken efforts to make sure that our standards are objective. So this is another illustration for those who may, I hope it's a good illustration. So the Board of County Commissioners adopts the subdivision ordinance, and once a developer or landowner submits a plat, we're in this black box here. And we have to apply whatever's in our ordinance at that time and evaluate the plat based off the standards in the ordinance. We can't use other factors or impose other conditions not contained in the ordinance upon that plat. But if upon, serving on the planning board for a couple of months or a couple of years, you think there's some deficiency, the option is for the planning board to make recommendations of ordinance amendments to the Board of County Commissioners. And they can consider those recommendations and adopt them if there's something about the process that y'all think needs addressed. Excuse me. So now I'm going to walk you through some kind of reoccurring concerns that I've heard expressed over my 6 years here with the county. And I want to be very clear about the things that I'm talking about. I do not mean to minimize any of these concerns. I'm not saying they're not important. I own property myself. I know that for most people, their home is their biggest financial investment. I also know it's more than just money. People's homes are special. So I want to be clear. I'm not minimizing any of these concerns. Instead, I just want to put them in context and how they relate to our subdivision ordinance and what it says or does not say in its current form. So there's often, I think y'all recognize this, there's often just general concerns about drainage. And what I would say to that is drainage is highly technical. And remember where we're at in the process. The preliminary plat is essentially lot layouts and roads and utilities, and it doesn't require detailed information about drainage. That's submitted in the construction plan that goes to the TRC after you approve a preliminary plat. This one's, I guess, a little bit more specific, but it relates to drainage as well. And that is the specific statement that an adjacent or a property owner in the vicinity says something like, my yard floods now. I would say that the county lacks the authority to require a subsequent developer to go in and improve the condition of prior development in the vicinity. And landowners have a right to make reasonable use of their own property. And the fact that a homeowner's property currently retains water does not mean that an adjacent property owner cannot make reasonable use of his or her property in conformance with the existing land use regulations on the books at that time. And also, just to reiterate, at the preliminary plat review stage, we don't know much detail about drainage because that comes later in the construction plan. Another concern that's often voiced is subdivision will create too many home sites or allows too much density. Our subdivision ordinance doesn't create different density standards. Density, I would say, is driven by the zoning classification. The zoning classification of the property drives the minimum lot size. So that's really not an issue, can't be addressed when a plat's submitted to you. Another issue that's commonly mentioned is concerns about traffic. And all I can say to this is NCDOT, I believe James said that that's one of the entities that's involved in the TRC. They review and comment on our plats, and all public roads, if the subdivision is going to have public roads, it must conform with NCDOT standards. And if there's going to be any driveways going to public roads, they also must comply with NCDOT requirements. Otherwise, our subdivision ordinance doesn't take into account any possible traffic impacts. I mean, we can't impose those type of conditions on a plat, at least in the current form as the ordinance is. Also, there's often questions about or concerns about septic issues. Our subdivision ordinance allows, doesn't restrict subdivisions to exclusively sewer, meaning people can have septic systems in subdivisions. And septic permits must be obtained by Pitt County Environmental Health, and that's a detailed process, and it follows septic rules which are adopted by the state. In the future, if a subdivision septic system fails, then it must be repaired in conformance with those rules set by the state, or the property owner can be subject to enforcement action by Pitt County Environmental Health. It's also often concerns about how the subdivision will impact school crowding. All I'll say to this is our subdivision ordinance is entirely silent on this issue, meaning that's not something that we can take into consideration. These next two are, I think, pretty closely related. People want to know what type of homes and what size of homes. This one's relatively easy. The county lacks the authority to dictate design elements of homes, meaning we can't talk about what color, what type of facade or architectural design elements. We don't have the ability to regulate that in any way. That's clear under state law, prohibits that. We also cannot set a minimum home size for 1 and 2 family residences. Another concern is, how will this impact my property value? Simply put, our subdivision ordinance is silent on this issue, meaning it's not something that we can take into consideration when reviewing a preliminary plat. Finally, there's some people have concerns about preserving open space, farmland, or nature. What I will say to that is, as far as farmland, subdivisions that are within a half mile or within a voluntary ag district must indicate that on the preliminary plat and the final plat. And I think the intended purpose of that is to let future home buyers know that they are buying in an area that is near agricultural uses, and to be on notice to expect things that are associated with agriculture, tractors, and livestock, and any type of issues that may be associated with that. So a landowner cannot buy and say, I had no idea that this farm was near me. But to those people who want to say that they're opposed to subdivision because they'd like to preserve adjacent open space or farmland or nature, just say that a landowner has a right to develop a property subject to the then existing laws and local ordinances. And if somebody, the planning board thinks that that should be more restrictive, or the governing board thinks that should be more restrictive, the remedy is to address that in changing the subdivision standards or changing the zoning density standards or something of that nature. These are not things that we can take into consideration when we're reviewing a plat. All these things that I talked about, these concerns, I just want to highlight that's how our ordinance currently treats them. Changes could be made in the future. What those changes, if there are any changes needed, what those changes would look like. That's not for me. I'm an attorney. I'm just telling you what the law is. I don't have any changes to recommend to you tonight. And finally, you may have noticed I said for administrative decisions, there's no required hearing. And you may ask, well, why do we have hearings for these if I say it's an administrative decision? The simple fact is, mail notice to nearby property owners for subdivisions is not required by state law, nor is it required by our local ordinance. In 2008, the planning board directed staff to provide notice to nearby property owners, similar to what is required by the zoning laws. And so that's where that practice comes from. It's not in the ordinance. Planning board could keep that practice or make changes to that practice. And that concludes my presentation. And I'm happy to answer any questions.
Oh, yeah, I have questions. Mr. Chairman, R.J. Hemby.
Yes, sir, Mr. Hemby. Ask away.
Yes, sir. Yes, sir. Yes, sir. First of all, thank you for that presentation, Mr. Smith. That was a beautiful presentation. Very informative. My concern is serving on the Board of Adjustment and also the Planning Board for the City of Greenville for 6 and 9 years, 6 years in one and 9 in the other. What I would like to see us build, and I ask this of the city, this is of the county, I would like to see a tree. That tree, how we would address the plat, that et cetera, because you're telling us all the things we can't do, and it's not. Then when we get in a public meeting, we look like that we are not informed, that we don't know our ordinances and laws. So if you could create a tree, each of us, we could actually look at and review when we are having these presentations. I think that we will look more informative, because what you've given us tonight is very informative. I would like to see that in the way of a tree. Thank you.
Mr. Hemby, I think I can, with staff, talk about something that, so you're talking kind of like a flow chart or some type of chart that summarizes what you can or cannot do. Is that, am I hearing you correctly?
Correctly. Dead on, spot on. Yes, sir. That's it.
Yeah, I'd be happy to speak with James and staff and try to create something and get it to y'all.
Thank you, Mr. Chairman.
Thank you, Mr. Hamby. There are other questions or comments?
John Landrine here.
Yes, Mr. Landry.
Just going back to what Mr. Little was saying in reference to, well, the whole thing, and speaking with Candace when she called, I think that maybe what he meant and what she meant was that we should have the final report from the technical committee so that we could ask the right questions. But in the process, I don't see how any of that's possible. That, my question makes sense?
Yeah, and I'd welcome James to chime in. I guess what I would say is, what I would offer is, we're here at the preliminary plat review stage, and y'all are the decision makers on that. You're just looking at this limited information really that's required. The technical review committee makes a recommendation to y'all on what y'all should do about that plat. And if y'all need more information from them, feel free to tell staff what that is. But I would just also, in that instance, they're making a recommendation to y'all as the decision makers on the preliminary plat. Separate and apart from that, later, there's the construction plan that's submitted to the technical review committee. And in that case, they are the decision makers, and that it doesn't come back to you. So I don't know this to be the case, but I feel like there may be some disconnect as to what the TRC does and when. And I just want to be clear that they review preliminary plats and give y'all a recommendation, and y'all make a decision on that. And then separate but related to that, later the TRC is looking at construction plans and reviewing those. And those are items that do not come back to y'all, but be happy for James to offer his perspective on that.
Sure, Jordan. Thank you, Mr. Landry, for your question there. Just know when we receive, a staff receives a major preliminary plat, we send that out to a number of review agencies, certainly to the people that serve on the technical review committee, but we send it to the school board, we send it to the utility providers, whether it's Greenville Utilities, Eastern Pines. So you do get the full report, all the conditions and requirements, everything that we receive back from that review, even some general comments. The school board might say, the schools in this district are Farmville Central and Farmville Middle School and Farmville Elementary. We'll get some input there. So all said, we compiled that information, provided to you along with the technical review committee's recommendations. So you are getting, I'll say, the final report for the preliminary plat. But as we move through the review process with the construction plan, and then at the final plat stage, that's handled by staff. We have a checklist. We go back to any of the conditions that you passed, that the construction plan also had available. We make sure those things are met before we approve the final plat. So it is preliminary plat is at your discretion. Technical review committee handles the construction plan, then staff follows up to make sure all those requirements are met before we approve and record that plat. So I hope that addresses, again, we give you everything that we receive, and we try to ensure that any of those review agencies that have some concerns, we try to ensure that they give you all their comments up front. And what causes some delays from time to time is if the review agencies are a bit behind in making their review comments. So we do provide those comments to you. And please, if you see some questions or you have some questions about any of the conditions that are provided, we'll be glad to address those to the best of our knowledge during the planning board meeting.
Thank you, Mr. Landry. Thank you, Mr. Rhodes. Does anybody have, did that address your concern?
Yes, yes, sir.
Okay.
That, I'm wondering if that also finished Mr. Little's question, if that was part of his question.
Yes, it was, and I appreciate the fact that they've been addressed. Thank you much.
And we do get, as Mr. Rhodes said, in our packet each month, we do get the responses from the various agencies on each of the preliminary plats. So we have them in writing, and we could certainly ask at the meetings for any additional information that we need from those particular agencies as well, if there's a concern. I think, and Mr. Smith could correct me if I'm wrong, but I think one of the problems that we face is that we're asked by the public that are responding to the preliminary plats that we get to make a legislative decision, whereas we only have the authority to make a administrative decision. And while we empathize with lots of the concerns with drainage and school overcrowding and all those type of issues that come before us, and we may need to look at those for a legislative remedy, but as a planning board, we are not the authority on making those legislative remedies. We're just voting administratively on whether or not the preliminary plat meets the guidelines that are and standards that are in the ordinance. Is that correct, Mr. Smith? Am I thinking on the right lines there?
Mr. Chair, absolutely. I think it's members of the public who show up and they want to be heard and they have all these concerns. And at preliminary subdivision review, most of their concerns are beyond what you can consider. If it were a rezoning of a piece of property, they can, rezoning, you're making a recommendation, a legislative recommendation. A rezoning, anything that they'd want to tell you is fair game and something you can take into consideration in making your decision to recommend or not. That's not the case with the administrative decision. And it's, I think, related that they get a notice, they get a letter and they come out and they want to be heard and they raise those concerns. And as I illustrated tonight, most of those concerns are not things that can be addressed by this board at the preliminary plat review stage, in my opinion.
And just to the other planning board members, we talked about the 2008, I guess, decision of the board that set this in motion for these decisions to be made by the board. We could certainly revisit that if folks wanted to do that. I'm certainly open to that idea. If you want to share those thoughts with me privately or in this forum, that would be fine.
And yes, Mr. Chairman, staff would really appreciate some input, some discussion about that, whether tonight or later. And I did want to bring to your attention, Mr. Fred Austin also has his hand up for a comment.
I'm sorry, I didn't Mr. Austin, I'm sorry.
That's all right. Thank you, Mr. Chairman. I did want to address a question to Mr. Smith. Is what exactly are the definitions and consequences of the different approvals that we are capable of doing currently? Like approve, conditional approve, or deny. It seems like the only thing that we really can do is conditional, because everything else follows after what we decide.
So, Mr. Olson, I'll try my best to answer the question. And so I would say 90% of what y'all do is conditionally approve. And that's because a subdivider has submitted a plat that meets those minimum requirements. And oftentimes what happens is the TRC makes a recommendation to you to approve it and attaches these additional conditions that weren't clear on the preliminary plat, conditions that came up as the TRC was reviewing that. So the TRC recommends these conditions that are related to things that are within the subdivision standards. And those conditions then attach to the plat and must be satisfied moving forward.
Thank you. And I do appreciate the staff and the TRC for making those recommendations as it becomes before us. But maybe this would be a suggestion to change our system, is what kind of follow-up is there when these conditions are determined by the TRC and we review it and give a conditional approval, that it has been followed through?
Yeah, so I mean, I think James would be the best person to speak to that, but essentially I think the short answer is they're followed, or the developer doesn't get to record the final plat, meaning they can't sell any lots. That's the short answer, but James can kind of talk more about how that happens.
Yeah, and just to give an example, the subdivision that you dealt with last month, that was actually in the Village of Simpson's extraterritorial jurisdiction, what happens is any action, any conditions and requirements that are approved as part of that conditional approval of the subdivision, we bring those forward. Those are sent to the developer and his agent, typically a surveyor or engineer. So when the construction plan comes in, we've got a construction plan checklist, plus we bring out any of those conditions that were approved by the planning board, and we treat that as a part of the checklist. We go down, make sure each one is met. We have a subdivision administrator here. Jason serves in that capacity. So when the technical review committee is brought together and they're at a formal public meeting, they're reviewing these plans. So if a construction plan comes in for the subdivision you just dealt with last month, Jason's already sent that out for review, gotten review comments in, also gone through the checklist that we have, all your conditions. So when it's prepared and presented to the TRC, we know what's missing, if anything. And a lot of times, and Jason will tell you, we'll send that information back to the agent or the developer and require changes. It is very common that something's been missed, an easement, a notation about a fire hydrant, whatever it might have been. So we get very specific at that point. And again, all those review agencies are right back in the game when we're reviewing the construction plan. And I will tell you, they will take the review of the construction plan more seriously even than the preliminary plat, especially, let's just talk about the Department of Transportation. If we've got proposed public streets, that district engineer is going to ensure that those roads meet all their standards, the curb radii, the roadside distance, any of those types of requirements are going to be detailed as part of the TRC review. So It is an elaborate review. What we could do is report back to you as construction plans are reviewed and when they might be approved. But just know, those construction plans, it's a 2-year window of opportunity once you approve or conditionally approve a preliminary plat to bring a construction plan through. So it's a good lag time on some of those. It's not immediate. So hopefully that addresses some of your questions or concerns. Again, we take this job very seriously. The last thing we want is that these development plans get some type of approval and they didn't meet certain requirements, whether it be from a utility company, whether it be from DOT, and all of a sudden we've got a substandard development out there. That's not going to reflect well on any of us. And we take great pride in ensuring that all those conditions are met.
Well, I certainly appreciate all the efforts and the professionalism that you go through, and also an appreciation for landowner rights as well. So I think you have addressed my question.
Thank you, Mr. Austin. Are there any other questions? Mr. Don Brown, do you have any questions?
No, sir. I am really getting educated and learning and thinking that the process, what Mr. Smith has presented is a great tool that we can use going forward to make sure things are in order.
Thank you. How about Mr. Moore? Tucker, do you have any questions or thoughts you'd like to add?
I just want to say great presentation and very helpful and informative. Thank you very much, Mr. Smith.
Ms. Barefoot? Do you have anything you'd like to add?
It was a good presentation and I have no questions.
Okay, perfect. And Ms. Buck, is Ms. Buck here? All right, I think that covers everybody. Mr. Little, you had an opportunity to speak. Did you have any other thoughts or questions that you had? I'm going to take that as good because I think you were still muted. But
I was. I'm good. Okay. I appreciate the presentation.
all right. Yes, Mr. Smith, thank you very much for the excellent presentation. And I'll move on to the next item on the agenda, which is our informational items from Mr. Rhodes.
Reader's Digest version.
Yes, it will be. Just a minute and I'll pull things up for you. Sorry for the very slow transition. I'm more used to using another video software package, so we'll see if we can't get going from here on. Again, we've got a few informational items tonight. Did want to bring you up to date. You probably read a few of our about a few of our presentations to the Board of Commissioners concerning the 43 South Corridor Land Use Plan. And just to give you an update, of course, the Planning Board had their public hearing back in February, recommended approval. We took this to the Board of Commissioners in March, held a public hearing there, had a number of comments from the residents, went back on in the first meeting in April, received more comments and more instruction from the Board of Commissioners. So Eric, Ben, and I have been working furiously on this along with our mapping staff, and we really believe at our next meeting, it was actually in the paper today that we would be bringing that back on May the 3rd. We think we have a good solution, a good compromise plan. It helps us and it also helps you and the Board of Commissioners as we're continually getting, I'll say, non-residential requests along the 43 corridor. We've got a plan developed that we think better addresses those items. The one thing that the process got bogged down in was about the sewer availability and annexations and a few things of that sort. So what we've done, based on our comments back from the commissioners, we have removed the suburban residential development category. And since the county doesn't have control over sanitary sewer service, for our land use plan, and the one that we'll be referring to for any of your rezoning requests, we have taken away that suburban residential component, replaced it with rural residential, and that's pretty much the way it's going to develop if it's on septic. So we feel like the plan still can serve our purpose here. We're hopeful we can get that approved so we can also get some of those other items addressed along the corridor. So we hope to report back to you next month, Mr. Chairman, that we've been successful with that, but we'll stay tuned. We did carry forward the conditional district rezoning that we dealt with at last month's meeting to the commissioners on Monday night of this week, and that conditional district rezoning was approved. I'm also happy to report that our staff is working hand in hand with Mr. Charez to get that site in compliance with our soil erosion regulations, and we're making some headway there. Always a good item of report is when any of these state maintained proposed state roads are taken over for maintenance by DOT. So we had a couple of subdivisions that those roadways have been taken through, they've met the requirements, and the Department of Transportation will be taking care of those from here on. We've got our monthly report. We've got some other correspondence in your package tonight. And as always, Eric's already alluded to, you can always go online, and any of the information we share with you during the meeting is readily available there, including all this amendment information, including the NC 43 South land use plan, the draft version. We welcome you to go online and take a look at that. So, Mr. Chairman, that's what we have for tonight. And again, thank you for your time and your service and ensuring, again, I want to offer thanks to Jordan also. This was a great presentation tonight, one that we'll probably pull out whenever we have new members join the board, just to make sure everyone feels comfortable with these types of review processes. So that's all we have for tonight, Mr. Chairman.
Thank you very much. And yes, thank you to the staff and Jordan, especially Eric and Jason, and of course, Tab, everybody. We appreciate your hard work and getting us through each month. And if there's no other business, I'll adjourn our meeting.
So move, Mr. Chairman.
Thank you. We'll see everybody next month.
Good night, everyone. Thank you again.
Good night.
Good night.
Painful.